My name is Abdul Sami and my student ID is EMV21288.
Hi, my name is Arbad Wahid. My student ID is VSS20346.
I am Asad Siddiqui. My ID is ISV2320.
We are studying at Holmes Institute, Sydney campus. Our subject is business law, and today we are going to give a presentation about a case which was between Mrs. Tame versus New South Wales. The plaintiff, the Mrs. Tame, had an accident in 1991. It was not her fault, and the case was generated just because of the negligence of the police. And the plaintiff took this matter to the court, and she was diagnosed with a high level of alcohol, which is 0.14. It was over the limit. At that time the limit was 0.05. At the time of rating belonged to the other drivers. Police, when the matter was taken to the insurance company, the insurance company also said that the plaintiff was not at fault, and they referred to the police because the police generated the wrong report, saying that she was having a high level of alcohol. And later on, police acknowledged their mistake and issued a formal apology letter between 2 to 3 months. However, there is no evidence that she was at fault, and due to this matter, she suffered depression, anxiety, and a lot of stress. In the meantime, she went to the her psychiatrist, and she was taking medicine for that, and she decided to sue the police because she faced circumstances which were beyond her control, and she was facing a lot of stress. She was having sleep issues. She was having sleep issues, and she was feeling helpless amongst her friends, and morally down just because of this decision, because she was thinking that she was drug driving. And the rest of the issues and legal case facts will my mate will explain it.
Alright, so I'm gonna talk about the facts of this case. So the facts or the elements concerned with tort of negligence in this case are as follows. So the first fact would be the police officer who completed the traffic collision report left the column blank and empty. The second one is the acting traffic surgeon made a documented error in completing the report. He reported Mrs. Tame blood level as 0.14, which is 3 times the legal limit. On the other hand, 0.14 was the blood alcohol for the other driver. The third fact of this case is that the acting surgeon had no contact or communication was made with Mrs. Tame. The other fact of this case would be the incorrect information was given to the insurance company NZI. The last fact, which is a bit significant as well, is her insurance payments were delayed. In that way, Tame obsessed with psychiatric depressive illness, and because she was considered as intoxicated, or she started thinking that she's an alcoholic, so she sued the New South Wales police for the negligence. So I'm gonna pass it to my mate Asad. He's gonna talk about the conclusion. Thank you.
So I'm going to talk about the conclusion, where the judgment of court, in which all of the 4 judges, Gleeson Chief Justice, Gordon Justice, McHugh Justice, and Kellyanne Justice, have agreed to that the negligence by the sergeant cannot cause a depression and cause it to visit a psychiatrist. which was not sufficient enough as by the New South Wales police. And as we can conclude in this critical analysis, that the police officers does not owe a duty of care to a person who is conduct under investigation, where the police has done their work properly and they have the sergeant's work to investigate the matter was done properly, and which could not affect Tame's negligence. And in respect with the conduct of acting Sergeant Bradley, there was no case of negligence against the respondent. Reason being, any responsible person in the position of acting Sergeant Bradley cannot foresee that his mistake in completing the traffic collision report carelessly would risk a psychiatrist's injury or appearance. Where the judges have also mentioned that a psychological injury is different to a physical injury, which cannot come under negligence of the police, where there's no physical injuries involved, and where the police has already sent an apology letter acknowledging their mistake, and this could not also result into Tame's distress and depressive behavior. It was not reasonably foreseeable that any in situation of Mrs. Tame would acquire a reconcilable psychiatrist illness from critical error. She was notified that the mistake has been rectified, and she also received a formal apology, which clearly tells that the police has done their work properly. There was no negligence with the police, which was rectified. The risk of such response was impulsive or fanciful, and in this manner specified in Wyong Spare Council via shared was not one of the law which of negligence required to reasonably person to avoid. That would be our conclusion with the case over here. So that should be it for our presentation.
Thank you.
Thank you.